This is Mark Strassman, reporter with California Politics Today. We're in the law office of Michael Sohigian, who is bringing a lawsuit on behalf of Melinda Birke against Oakswood Garden Apartments in Woodland Hills, and we're here to talk about the case. Welcome to California Politics Today.
Thank you, Mark.
This lawsuit was filed on June 28th, 2006, the day after the U.S. Surgeon General made an important announcement about the toxicity of secondhand smoke. Could you talk about what that announcement was and what relation, if any, it had to the timing of the filing of this suit?
Well, the Surgeon General determined for the first time that secondhand smoke is a toxic carcinogen that poses a serious threat to public health. That followed by about 4 or 5 months of finding of the California Air Resources Board that was the same in its focus and meaning. So what that means is now that far from there being really a controversy about whether secondhand smoke is a toxic substance that poses a serious public health risk to non-smokers, merely by virtue of their exposure to it. Everybody agrees now, both the state of California and the government of the United States agree that that is so. There really is no room for dispute.
And in terms of law or legal proceedings, it becomes an established fact by virtue of the California Air Resources Board and the Surgeon General issuing these reports based on scientific study and analysis. Is that important?
I think that
it no longer becomes a point of contention, or does it?
Well,
in other words, is it alleged harm or is it actual harm according to the law based on these scientific reports?
I suspect that the defendants in this case will continue to dispute those issues. I think it is much more difficult to prevail in an argument about the health consequences, excuse me, of secondhand smoke. Now that the state of California and the United States Surgeon General's office have both taken a position that really brooks no dissent on that issue.
Okay, so that's the scientific side of this. Talk about this case in particular, how you came to be the plaintiff's attorney in it, and what the background is.
Well, John Birke is the father of a 5-year-old daughter. He and his wife and his daughter Melinda live in the Oakswood Apartments in Woodland Hills, and John lived there before Melinda was married and during the entire time.
Born.
I'm sorry, before Melinda was born, that's right. Yeah, Melinda's not
She's
married
not married
yet.
yet.
She's only 5 years old.
old.
John lived there before Melinda was born, and during the entire time that he has lived there, the management has allowed smoking in what we describe as the common areas, the area around the swimming pool, outdoor dining areas, the playground. And John has in the past complained to the management about that. Melinda was born in 2001, in February of 2001. And since then, his complaints and his concerns about the issue have taken on greater urgency, obviously.
He was disturbed by it before she was born, and attempted to do something about it.
He
before.
did.
And what kind of reaction did he get when he tried to do something about it?
Well, the reaction that he got, the reaction that we describe in the complaint, really came about after Melinda's birth.
Okay.
And what he was told by the management of the building was that they had made, in essence, a business decision not to antagonize their smoking tenants. And so because the law, as they viewed it, did not require them to restrict smoking in those areas, they were unwilling to do so. Now, when the California Air Resources Board and then subsequently the U.S. Surgeon General issued their reports, we viewed those findings and those official positions as establishing that secondhand smoke in those areas is a condition that is harmful to health. And it occurred to us that that those findings, those developments really in the science of secondhand smoke made it possible, or at least I think it was always possible, to sue on the theory that we've alleged in the complaint. But those developments made that theory much stronger. So in February of this year, soon after the Air Resources Board report came out, John contacted again the management and described in a letter our plans to take legal action in the civil courts. And again, we received at that time a letter from an attorney, but the response was that they weren't willing to do anything.
Now, if the California Air Resources Board and the Surgeon General have stated that there's no safe level of exposure to toxic, carcinogenic secondhand smoke, why is it possible under the law for people to do it or to facilitate it?
Well, you'd have to ask the legislature that question, obviously. I don't have the authority to make laws. That's the legislature's job.
So by the fact of this threat, there is no law in place that would prohibit it.
No, there isn't. But of course, the civil courts exist to permit individuals to vindicate their own civil rights.
Before we talk about that, which I want to focus on, is this an exception to the rule? Are there other carcinogenic and toxic substances that the law does not prohibit people from producing and distributing around the space that people use to breathe? Toluene, benzene, thousands of chemical compounds, many of which are in tobacco smoke, and others which are generated in other ways. Can people pollute the air with toxic and carcinogenic substances unless the government specifically passes legislation prohibiting them from doing that?
Well, I mean, you asked kind of a broad question.
Right.
The law of nuisance provides individuals with the right to take action to protect themselves against acts of others that are harmful to their health, offensive to their senses, or otherwise interfere with their enjoyment of property.
That's essentially a common law rule,
Right,
isn't it?
exactly.
Okay.
The
All right.
law of nuisance has been around for hundreds of years.
Okay, well, focus on that and how that relates to the fact that if the government hasn't acted to prohibit something, individuals can assert their own rights in civil litigation.
Sure. Yeah, I mean, the fact is, of course, that there is regulation of the kind of activity that you're talking about, automobile exhaust, diesel fumes.
DDT.
Yeah, all kinds of things. Now, some things are banned, as is DDT.
Right.
Other substances are not banned, but their use is regulated, and there are legal requirements to handle them and to notify others and so forth. Those are acts of the legislature and issues of public enforcement. Our lawsuit is based, as you said, on common law dating back centuries, to allow individuals to enforce their private rights in civil court. Now, it is true.
Essentially, life, liberty, and the pursuit of happiness, in a sense.
Sure,
Right?
of course. Of course, life, liberty, and the pursuit of happiness is a construct that is younger than nuisance law itself.
Right.
But on the one hand, of course, we have a single plaintiff, who is Melinda Birke, who is suing to vindicate her own rights as a person, as an individual, to be free from these conditions that we describe as nuisance. But naturally, our goal is to get these defendants to take action that we believe they are obligated to do to protect the health and welfare of their own tenants, who, after all, pay rent to live in that building and to use the facilities that they make available.
Now, in terms of precedent or expansiveness, assuming you prevail in the case, and we're going to talk about some of the details in the process in a second, assuming you prevail, will you have established the precedent that those people controlling property have an obligation as a general principle that you will have established, to protect their guests, tenants, visitors, and others from the deleterious effect of secondhand smoke?
Practically speaking, the answer to that question may be yes. Legally speaking, the answer to that question is almost certainly no. Legal precedent is made by opinions of the Court of Appeal or the Supreme Court. So, for example, even if we try this case and get judgment for the plaintiff, we will not have set legal precedent, because that precedent could not be set by a trial court.
It can be, but let's assume you win. I would guess that the defendants are going to appeal, or maybe they'll think that they don't want to set precedent and they won't appeal.
Yeah.
But if you win this case against Oakwood Garden Apartments in Woodland Hills, would another asthmatic child or any person in another apartment building somewhere else within California have an automatic slam dunk case, or how would that work in terms of theory and practice?
I don't think so.
And this isn't a class action suit.
No, this is not a class action suit. As a legal matter,
right,
the outcome of this case, if it's positive, is unlikely to have the effect that you've described.
Okay.
As a practical matter, however, I suspect that it will get the attention of landlords throughout the state, and that the outcome of this case will influence landlords' conduct in the future. Already, the case has drawn a fair amount of attention. That's why you're here today.
Right.
And I have received communications from people all over the country about these claims and about this case. It seems clear to me that apartment landlords in the state of California will pay attention to what happens in this case, and they're likely to conform their conduct to the result.
Okay, let's focus a little bit on the details of the case. The term that's used to explain the status of Melinda Birke as a 5-year-old is that the suit's being brought by her guardian ad litem. What's a guardian ad litem, and what's the status of that sub-procedure in this case right now?
Well, the law does not allow a minor to sue. Because Melinda's only 5 years old, she needs to have a guardian for purposes of litigation. That's why it's called a guardian ad. We sometimes say litem rather than litem.
But sure you do.
Melinda's guardian ad litem is her father, John. We filed with the complaint a petition to appoint John as Melinda's guardian ad litem, and that petition is awaiting the court's ruling. It's by and large a pretty formal issue. We don't expect there to be any serious problem with that petition.
And until that petition has been certified or accepted, approved by the court, what about service of process to the defendants?
Yeah, the court will not issue a summons until the guardian ad litem has been appointed. So without a summons, you cannot serve the lawsuit on the defendants. So we're sort of in a holding pattern. Oakwood knows about the case. In fact, I've conferred with attorneys representing Oakwood about the case. I sent to the lawyer that we had heard from back in February a copy of the complaint, really as a courtesy when it was filed. So they're aware of the claims and the nature of the claims.
Can you say whether settlement negotiations are underway, even though they haven't even been served yet?
I can't say.
You can't say, okay. What's the timetable for the consideration of course after the summons is issued and so on? What's the timetable?
Well, there is a case management conference. I mean, these are very sort of mundane legal issues that is set for, I believe it's October or November. I mean, the case will move fairly slowly to an eventual resolution. This is very, very early in the case. We've really only filed a complaint. Now,
can you say anything about who you see as opposing counsel here, and who is going to be representing Oakwood, or is that have to wait until you serve them, or what?
I know who will be representing Oakwood, but I think that's less of an issue in my mind than who will be supporting Oakwood.
Well, that was the next question.
I
who will be?
anticipate I anticipate that apartment owners generally will oppose our lawsuit.
Now, I interviewed the Senior Vice President for Public Affairs of the California Apartment Association yesterday about this, and asked if she would, if her organization would be supporting the defendants here, and she said they don't do that at before the appeal stage. Does that sound reasonable, or are they going to give them moral support or financial support? What's the position of the landlord community on this, as you see it, and how important is this to them? How much energy and money do you expect they're going to put into defending against your suit?
Well, I can't really speak for the landlord community. I really don't know.
Right.
But I do know that I've been contacted by numerous apartment tenants,
right,
complaining about the same sort of thing since this case was filed.
Right.
And their experience, as they tell me, is that their landlords are generally not very solicitous of these concerns. So I expect that landlords in general, as I say, will be watching this case. I think what the public affairs person told you is probably true. There really isn't any opportunity for groups like the Apartment Owners Association to get involved in a case at the trial level.
Do you think that the tobacco companies are likely to get involved at any level in terms of, I don't want to use the word moral support from them, but the financial support of the defendants here?
Well, it's hard to know. We'll just have to wait and see. My own view, frankly, is that the claims in this case are rather strong. I don't think that we will have any difficulty establishing that permitting smoking in these areas and the consequences of that are a nuisance.
Are you looking for or have received moral support or financial support from anti-smoking organizations? Is there a Save a Melinda Birke fund that individuals or anti-smoking organizations can contribute to help bear the costs of the litigation on your side?
There is not yet. I have received certainly moral support, and there's a great deal, obviously, of information, scientific and otherwise, that it is helpful.
Do you expect that this will be, if it goes to trial, a trial before a judge or a jury? Are you asking for it to go before a jury?
We've asked for a jury, and we expect that if the law permits that. I mean, there's some claims that cannot be tried to a jury. I believe that this is not one of those claims. I think we have a right to a jury trial, and we've demanded one in the complaint.
Okay, before I ask what you're demanding in the complaint, maybe you could read an excerpt from the suit itself. I think paragraph 8 pretty much gets to the core of what the complaint is. Mm-hmm. Maybe you could read that for our audience.
Well, I can read it. It's legalese.
That's all right. Well, let's give them a taste and see how
it
this
says,
works.
from May 1993 to the present day, defendants have allowed, encouraged, and approved a toxic, noxious, hazardous, offensive, and in fact carcinogenic condition to be present in all of the outdoor common areas of the complex, including partially enclosed areas. This condition is secondhand tobacco smoke and results from tenants and visitors smoking cigarettes and cigars all over the grounds. As a result, secondhand smoke often pervades, among other areas, the swimming pools, the common barbecue areas, the children's playground, the outdoor dining areas, and the areas immediately outside the entrances to the rental office clubhouse. In addition, there is no area in the entire OGA, that's Oakswood Garden Apartments complex, where one cannot find multiple cigarette butts, including all of the walkways, planted areas, and the stairwells, as well as the areas identified above. As a result, Melinda has picked up butts from the sidewalk. Melinda also is informed and believes, and on that basis alleges, that other toddlers have come into hand or oral contact with the pervasive butts littering the OGA grounds.
So this is a suit filed on behalf of toddlers, isn't it?
Well, we're hoping.
Okay. I'd like to sort of move over to the side a little bit and talk about the economics and psychology of what's involved here. Before smoking was banned in restaurants, and the restaurant owners made the argument that they would suffer grievous financial harm if that happened. Did that happen? And what kind of precedent does that set in terms of argument for presumably the arguments from landlords that they'll suffer grievous economic harm if this is implemented?
Well, it did not happen. eventually the smoking cigarettes was outlawed in restaurants and bars throughout the state of California, so there was no competitive disadvantage between restaurants and bars anywhere in the state of California. But even when the city of Los Angeles, for example, outlawed smoking in restaurants, there was, to my knowledge, no appreciable decline in patronage. And I anticipate that the same would be true here. The fact is that surveys show that well over 3/4 of apartment tenants favor banning smoking throughout their apartment complex.
That's roughly comparable to the proportion of the population that's non-smoking, isn't it?
It is, but in fact, even smokers, 2/3 of smokers favor banning smoking in apartment complexes.
Okay, well, that leads then to the poor addict smokers whose freedom would be, or ability to do what they want would be limited by this. What's your take on their plight, on their rights to do what they want, where they want, even if it harms other people?
Well, nobody has a right to do what he wants, where he wants, to the exclusion of its effects on other people.
And that's pretty much an established principle of common law for hundreds of years, isn't it?
Of course. So everybody's rights come into conflict, and that's what the courts and the legislature deal with every day. Now, the fact is that people are free to smoke in their homes, and tenants of the Oakwood are free to smoke in their apartments, and they would be regardless of the outcome of this lawsuit.
Is there a movement or a legal rationale according to which people, especially people who have children, would not be permitted to smoke within the privacy of their own home or apartment because of the damage that's being done to the children or the other people in the living unit?
Well, I don't know. That's not what this case
Right.
is about. So is it possible that someone could make an argument based on a legal rationale? I suppose it's possible, but that's not something I've given any thought to.
What about the reasoning that prohibits smoking within office buildings like the one we're in here, and allows the workers within the building to take smoking breaks and cluster themselves near the entrances, so that a random person entering the building who might not be exposed to any smoke whatsoever, in the condition where all of the smokers are congregating outside the entrances, ends up being exposed to the same carcinogenic toxic chemicals that you're alleging need to be stopped in this case?
Well, of course, that's a different issue, because in this case we're talking about common areas that the landlord makes available to its tenants as part of the benefits that they enjoy as rent-paying tenants in the building. And again, we're talking about residential facilities,
right,
which are of a different character.
I'm trying to see how far the logic extends. Obviously, guests have fewer legal rights than residents, but it's included within the supposition, it would seem to me, people visiting an office building to do business have some status under common law, and I'm wondering whether their right for the free enjoyment and passage into those buildings contradicts and could supersede the rights of the people working in the building to do to them what the people in the common areas in Oakwood Apartments are doing to Melinda.
Well,
you see
again,
right.
It's not something I've given much thought to.
Right.
The courts, as I say, weigh the rights and consequences of people's conduct all the time. I really wouldn't feel comfortable talking about it in the abstract.
Okay.
It's just not something that I really can express.
Okay. The representative of the California Apartment Association said, among other things, that she felt that this suit was in part a result of anti-smoking fervor directed against a surrogate for the government that hasn't, as we've talked about, prohibited this behavior. Is that a valid argument in your view?
Oh, I don't think so. I think that as we discussed, the civil law concept of nuisance has existed for hundreds of years. I'm not sure that I really understand what you mean when you say anti-smoking fervor directed at a surrogate of the government. But
she was saying people people, unnamed people, are pursuing this course of suing apartment owners because they don't get the relief that they would otherwise have if the government were to ban smoking in public entirely.
Well,
so they have to go after the landlords rather than having a remedy in the law generally.
Well, all I can say about that is that the legislature is not the only recourse that citizens have to the law. The courts exist for the purpose of litigating, the civil courts at any rate, as opposed to the criminal courts, exist for the purpose of allowing individuals and private parties to vindicate their rights under the law. So, as I've said, apartment tenants have rights under the law. They have rights in their residences to be free from harmful conditions that are offensive to their senses, and conditions that interfere with their quiet enjoyment of the premises that they pay to occupy.
Now, you said this isn't a class action suit. Would there be any impediment to launching one if the appropriate collectivity of potential plaintiffs got organized? And would you be interested in being involved in that as a follow-up to this?
This case could be a class action suit.
It could be converted at a certain point? How would that work?
How would the suit be converted to a class
right.
action case? I don't know. Oh. I really don't know. I mean, that's
because there is some language in the complaint that refers to the rights of the other toddlers and the other tenants of the building. Mm-hmm. But they're not now. Could new plaintiffs join the suit, or would you want to do that, or would you want to have another suit for other tenants in other buildings, or how might that work?
At this point, frankly, Mark, I am interested in vindicating the rights of this little girl. I recognize that as a result of a successful outcome of this case, it is likely to benefit all of the tenants at the Oakswood Garden Apartments. But my focus right now is on litigating the case that we have pleaded on behalf of Melinda.
Okay, I understand law is above personality, but do you have any personal interest in this? Are you a non-smoker? Do you feel it would be a nice idea for people like you and other non-smokers to be free of toxic and carcinogenic smoke wherever they happen to be?
I am a non-smoker, and I believe that the law, as we have pleaded it, is correct, and that Melinda, in this case, has a right to be free from the conduct that we have alleged has caused her damage. But I understand the concerns of smokers. Unfortunately, they are really, in some ways, victims because of the addictive qualities of cigarettes. I think the cases and the scientific evidence has established that after a while it ceases to be a matter of pure choice. Obviously, individuals can quit smoking cigarettes, and millions of people do so all the time. But I'm sympathetic to them, and this is certainly nothing personal. I'm not hostile to smokers or anything like that. My concern is just that this little girl's right to be free from these conditions be vindicated in a court of law. So I think it should be.
Could you wrap up by enumerating what you're asking for in the case, what you're asking the court to do?
Well, we are asking for an award of damages, and we would like to have injunctive relief. We'd like to have an injunction issued to prohibit smoking in those common areas. And then there is the possibility of recovering attorney fees if we prevail under what are called the private attorney general statutes. We will have, as we've discussed, conferred a substantial benefit on a large number of people by virtue of this suit, if we are successful, and we would be entitled under the statutes to an award of attorney fees against Oakwood. Oakwood, in essence, would be ordered to pay the attorney fees and costs incurred in our litigation.
So say that again about, essentially you said private attorney general there? Explain that concept and how it would figure into this.
The law provides that if a plaintiff confers a substantial benefit on a large number of people by virtue of litigation.
Which could extend to all the apartment dwellers in the state of California.
It could, but inarguably it would extend to all the apartment dwellers at the Oakwood if we were successful.
Right.
That the court may award attorney fees and costs of litigation to the prevailing party who has, as I say, conferred this substantial benefit on a large.
So even though it's not a class action suit, if it does confer this benefit on a larger group than just the individual plaintiff, then you'd be entitled to some compensation for that.
Correct.
All right. Any last words you want to say about what the public should look for in this case, and what you think the significance of this litigation is?
Well, I think that this case is, even though it's a trial level case and not a matter of legal precedent, this case really is a test case for the application of these very ancient legal doctrines to a new issue in our society. And I anticipate that there will be continued interest in it and continued coverage by members of the media like yourself to keep Californians rather, informed about this lawsuit and efforts to vindicate their rights.
The facts of this, the danger of the smoke, it has been around as long as Walter Raleigh and his cohorts towards the beginnings of common law. Are you saying that the reason this suit can go forward now and it couldn't go ahead in 1900, 1800, is because the Surgeon General and the California Air Resources Board have declared as scientific fact that there is a harm here? Couldn't it have been, or has science only advanced most recently enough to substantiate these claims, or why couldn't the suit have been brought in 1800?
Well, certainly in 1800 and the 19th century,
right,
and probably through most.
Or 1964, when the Surgeon General said smoking causes cancer.
Well, actually, the Surgeon General in 1964 said smoking may be injurious to your health.
Right.
It wasn't until the 80s that the Surgeon General took a categorical position on that.
Then why not 20 years ago then?
Well, it is a matter, obviously, of social attitudes changing, and it is also a matter of scientific evidence mounting. Now, our case is not about smoking being injurious to the health of smokers. That's well established and has been well established for decades. Our case is about smoking being injurious to non-smokers. That's what secondhand smoke is about. And that scientific case has not been as well established until relatively recently. Now, as the Surgeon General has found, there is no question that exposure to secondhand smoke is injurious to the health of non-smokers.
So now the question is taking the scientific finding and establishing it in law.
Well, I think this case probably could have been filed earlier, but we are helped by the scientific finding, no doubt.
Thanks very much for talking to us on California Politics today.
You're welcome, Mark. Thank you.